Hi, so in this video we'll talk about EU law and national law and the relationship between both the legal orders. This obviously won't be like a full course or full lecture on EU law. It's actually a presentation I held at a university in Estonia, so it's not complete, but I think it provides a good overview, especially on the relationship of both legal orders. So who might this presentation before? Obviously, if you're a legal student and you have to take a class on EU law, this might be a good summary, hopefully. And also, if you're just interested in the European Union, EU law, and what legal acts the EU can actually make, regulations, directives, how this goes into the national legal order, how you might be able to invoke EU legal acts before national courts or your national administration, then this might also be for you, this presentation. Okay, we'll look at several things, but obviously there are also several things we won't look at. There's a lot you could talk about in EU law. You could talk about the economic freedoms. You could talk about the fundamental rights charter. These are all things that we'll not focus on in this course. We'll talk about them on the side, but the focus really will be about on the relationship between EU law and national law. This will also be a longer video, so there will be chapter marks, so you can come back, jump to the chapters you want to actually listen to. And what will we talk about in this course? Well, or in this video, we'll talk about the relationship, as I said, between the EU legal order and the national legal order, and basic principles, for example, the primacy of EU law, which is a term you might have already heard, the primacy, the precedence of EU law. And we'll talk about how the European Court of Justice has developed this principle and how the court reasons this principle. Then we'll talk about how member states approach, the member states' constitutions approach the relationship between EU law and their national law, and whether they accept primacy and to what extent they accept primacy. We'll look at the some constitutional courts and their jurisprudence on this matter, and then we'll look more detailed into the EU legal order, and we'll talk about primary law, so the treaties, the Charter of Fundamental Rights, not that much. And then we'll talk about the main legal acts, which are regulations and directives. We'll look at what are the similarities, what are the difference between the two legal acts. And then we'll get into more detail. This will be then a more specialized thing we'll talk about. We'll talk about direct applicability of EU law and direct effect. So which EU law has direct effect, because direct effect is quite important for primacy. So the question, whether EU law wins or national law wins. And then we'll talk about one particular problem in EU law, which is very important in legal study, but also obviously in cases, cases before national courts, and which is the direct effect of directives. So the question when you can actually invoke a directive before a national court or a national administration, because as you might know, for regulations this is easy, but directives usually have to be transposed into national law by the national legislator, and so it is kind of tricky to directly invoke them, to directly rely on a provision from a directive, and we'll talk about the cases where that is actually possible. So if that was too complicated for you, we'll get into what that actually means, what I just said, but in case you already have some EU law background, then you might know what our main goal will be in this video, what we'll try to understand in the end. Okay, so let's start with I think you could argue like the most important decision of the European Court of Justice. So the European Court of Justice is obviously like the court, the highest court of the European Union. There are two, and the ECJ is like the top authority when it comes to like the interpretation of EU law, which is regulated in Article 9 of the Treaty on European Union, so one of the founding treaties of the European Union, which we'll also look at later. And basically, one of the principal decisions that we should know in EU law is a case from 62, which is called Van Gent en Loos, or Van Gent en Loos, I guess, if you speak Dutch. And in this decision, the ECJ established like the main, which you could call the main like special thing about the EU legal order, because I mean, basically, if we think about the EU is like an international organization, like an institution of international law founded by treaties between member states. So we have the, different treaties throughout history, treaties of Rome and of Maastricht and Lisbon and so on, where we had like different treaties like concluded by the member states. And well, basically in that sense, like just like the United Nations or something, the EU is just an institution of international law. And this is also what the ECJ will say here. And usually what we have in international law, I'm not an international law expert, but usually what you have in international law is that you have institutions which can sometimes make law, and you have like international treaties which constitute international law, but these acts of international law don't apply directly in the national legal order. So in order to like have effect in the national legal orders, these acts of international law have to be transposed into national law by the national legislator. And this, in general applies also to like EU law, because EU law like technically is nothing else than like international law. But the ECJ established something here which is not in the treaties, like he read this from the treaties, but which is very important. So the ECJ says that, as we can see, the conclusion to be drawn from this is that the community constitutes a new legal order of international law. So the ECJ says the EU law order is international law, but it's like a new legal order, and it has some specialities, which we'll talk about now, for the benefit of which the states have limited their sovereign rights, albeit within limited fields. So the first crucial thing about the EU law order that we have to understand is that by concluding the treaties, the member states have given certain competences to the EU, and they have, in that sense, limited their sovereignty. You can discuss what sovereignty means and whether, the member states are still like fully sovereign or not. But, what is definitely true is that like the member states have given certain competences to the EU, and for example, it could be some competence in economy law or nature law, or whatever field you're talking about, and like environmental law, for example. And the member states have given the EU this competence, and now the EU enacts in this field of competence, can enact like legal acts, and these legal acts then apply in the member states. So this is like the first element of what we also call like supranational the supranational EU legal order. So it's more than like just international law. What we're talking about supranational law, because the EU has the possibility to adopt legal acts that directly influence the national legal order, that directly apply in the member states. And this is, the difference that I try to explain to international law in general, which doesn't take effect in the national legal order until it is transposed. But the EU has this supranational element, it's above the member states, and it can enforce legal acts or create legal acts that directly apply in the national legal orders. And the second thing, which the ECJ says in Van Loos, is that the subjects of this legal order, this new autonomous legal order, the subjects of which comprise not only member states, but also their nationals. And this is also quite a stark difference to international law, because in international law, usually the subjects of international law, you can debate, if there is a change with individuals, but usually the subjects, traditionally the subjects of international law are states, member states. International law is contract law, contracts between states. But the international law does not directly give the rights or obligations to people like us, natural persons or corporations. But it only gives rights and obligations to states. And then those states might transpose the international law into the legal order, which then can give rights and obligations to individuals, but not the international law itself. And this is the stark difference, because the ECJ says that not only does EU law directly apply within the member states, but it can also directly give rights and obligations to individuals, to us. So I can directly invoke or get, a right or an obligation from EU law. So, for example, if you think about the GDPR, which is probably something all of you have already heard of, the GDPR can give a right to me. For example, Article 15 GDPR gives me the right to request, from, for example, a company, what information they hold about me, what personal data they have saved about me. That is a right, a claim I get directly from EU law, or flight compensation would be another example. So if my flight is delayed more than 3 hours, there's passenger rights regulation, and I might have a claim directly from this regulation, directly from EU law, against, for example, my airline or my neighbor or the state. So this is the two things that the ECJ establishes in Van Loos, which form the speciality, the supranational EU legal order, which is first transfer of competences, transfer of sovereignty from the member states to the EU within the treaties, and also the direct applicability and the possibility to directly give rights and obligations to the citizens, or to nationals living in the EU. Right. And autonomous basically means that what the ECJ has said here is that the EU law is its own legal order, and the ECJ also has said in subsequent decisions that the EU legal order, so any terms that we have in the treaties, any provisions, have to be autonomously interpreted. So if we have a word in the treaties and we also have that word in national legislation, the treaty term might still have a different meaning. It has an autonomous meaning, and obviously Article 19 TEU, that meaning is defined by the ECJ. So the ECJ has also given itself quite some power through these decisions, because basically the ECJ is the only is the highest authority when it comes to like interpreting the treaties, and also like interpreting secondary law and deciding on the deciding whether secondary law, what we'll talk about, is valid or invalid. So if you say that like we have a very powerful EU legal order which can directly influence citizens and which is autonomous, then obviously the ECJ is like the final authority which says like how EU law is applied and how it actually influences the national legislation. So this is also, you know, important for the ECJ to give itself a lot of influence, right? And there's a second decision that we'll get into now, and this decision was actually was the decision that not only like invoked the EU legal order but also primacy. So right, so you can actually see it better, maybe like this. This is Van Gent-Loos in 63, and then there's also Costa. Costa is from 64, so Costa v E.N.E.L. And Costa E.N.E.L is the decision that actually, you know, for the first time the ECJ said that EU law has primacy over national law, and we'll talk about exactly what that means. But this was Costa was a case where Italy wanted to nationalize its energy companies, and basically there was a conflict between like the treaty, which said you couldn't nationalize like the energy companies. I'm simplifying this a lot, but like and there was a later law, which was an Italian national law, which was adopted later, like the Nationalization Act, which said that, you know, Italy will now nationalize all these energy companies. And there was Costa, which was a citizen, which had like shares in the Italian energy companies. And basically he said, well, this nationalization law is against the treaty. And I think the Italian Constitutional Court, they just applied lex posterior. So lex posterior is like the basic principle of law, that if you have two conflicting laws on the same level, you look at which law was passed later, and then you apply the later law, because, you know, usually the legislator will have thought about what they have done before, and then you apply the later law, lex posterior. So the National Constitutional Court just said, well, also when it comes to the relationship between EU law and national law, we'll apply lex posterior. So we have EU treaties that say one thing, but then we have a later, like a subsequent national law which says something else, and then we take our basic legal framework, like our basic legal principles, and we apply the subsequent law. And so Italy can nationalize these energy companies. And before they did that, they asked the ECJ for its opinion, like preliminary ruling, which you can request or have to request according to the treaties from the ECJ. And the ECJ said, no, you can't. You actually can't override EU law with a subsequent national law. And the reasoning is the following. It follows from all these observations that the law stemming from the treaty, so we're talking about the community law. At that time it was called like the European Communities. Now it's called the EU, so we just say EU law. An independent source of law. So again, you know, coming back to Van Gent-Loos, like we have this autonomous legal order, could not, because of its special and original nature, be overridden by domestic legal provisions, however framed, without being deprived of its character as community law and without the legal basis of the community itself being called into question. So what the ECJ is saying here is, well, we have the treaties, and the law stemming from the treaties, which might not only be the treaties, but also like secondary law acts, like regulations, directives, these can not be overridden by domestic legal provisions. So we can't apply lex posterior, because what would happen, and from the ECJ perspective, this makes a lot of sense. What would happen if we just allowed states to apply subsequent legal provisions in national law? Well, we would deprive the EU law of its character as community law, and we would call into question the legal basis of the community itself, because what is the idea of the communities and what is now the idea of the European Union? Well, it's originally it was mostly like to form an internal market, with without internal borders, but most importantly, it's harmonization. So it's harmonization of the law of the member states. So you actually have the same law that applies in all of the member states. So you can like freely trade on the internal market. You can like move around in the internal market, like the 4 economic freedoms. You can work anywhere. You can export your goods without like duties, like without taxes, without like tolls at the border, and like without tariffs. I thought of the word now. We've heard that word a lot, like in recent months, like without tariffs in the internal market. And obviously, to have this, like this is the goal of the treaties. And to establish this, we obviously need like a common application of EU law. So the ECJ basically argues, well, if you allow member states to override EU law by just passing subsequent national acts, then the EU law, won't be uniformly applied in the member states, and the whole idea of the communities, basically, or now the whole idea of the union, doesn't work, because the idea is that all the member states have to, like, at least in the areas where they have limited their sovereignty and they've given the EU the competence to make law, then it has to be uniformly applied in all the member states, because otherwise the union doesn't work. Okay, so this is actually, I would say, these are the most well-known and probably most important decisions when it comes to the fundamentals of EU law. So it's Van Gent and Loos, autonomous legal order, and it's Costa, the primacy of EU law over national law. And actually both of these things are not in treaties. Primacy, for example, is not in the treaties. It's just that something that for the ECJ follows from the treaties, because otherwise the whole idea of the union doesn't make sense. Actually, there was the idea, we'll talk about that later, to have a constitution for Europe, to reform the treaties in around 2004, 2005. And there was actually a constitution for Europe that was supposed to be, established, signed by all the member states, ratified by all the member states. And in that constitution, there's actually an article which says that the law of the European Union shall have primacy over the law of the member states. So we would have put it into writing, but this constitution was not ratified by all the member states, I think in specifically Netherlands and France, because as I explained, the treaties, the founding treaties of the EU are international law, and how international law is ratified by the member states is actually dependent on the national constitutions. And in some member states, for example, Germany, you just need a law by parliament that accepts, the treaty to ratify it. But in some member states, you need a referendum. And in Netherlands and France, this constitution for Europe did not pass the referendum. So this was actually not written even not in the Treaty of Lisbon, which was in 2009, but that was a bit maybe too much to actually put it into writing. But still, it is accepted, EU law, because since 64, the ECJ has always held primacy of EU law. And we'll talk about what that means and like how far the member states are willing to accept primacy of EU law, because this is obviously, you can imagine, quite controversial, like how far we should go with the primacy of EU law. All right. So next, we'll look at this autonomous legal order, because so far we only know that there is an EU legal order and that it takes primacy over the national law. So the EU legal order is basically made up like any national legal order. So you can think of it like a pyramid, which I will show in a second. But you can think of it as a pyramid, and there's obviously a hierarchy. Like in national law, we'll look at the national law next. But we have something at the very top, and then we go down. And at the very top of the hierarchy of the pyramid, we have the primary law, which is already in the name, that it's like primary. And the primary law of the EU is made up of the founding treaties. So this is the Treaty on European Union, TEU, and the Treaty on the Functioning of the European Union, TFEU. And then their protocols and annexes, that's not that important. And also Article 6 of the Treaty on European Union tells us that the Charter of Fundamental Rights, which was put into place later, actually also has the rank of primary law. So it has the same level, the same rank as the treaties. So if you were to compare it to a national order, you could think of this as the constitution of the EU, like the treaties and the Charter of Fundamental Rights, like you would have in a lot of constitutions. But obviously, since the treaty hasn't passed, we don't call it the constitution. We just call it like primary law, the treaties. Right. And then below that, we have the legal acts that the EU itself actually puts into place. Like the EU actually concludes, and these are mentioned in Article 288 of the Treaty on the Functioning of the EU. I can actually show this to you. So here you have Article 288, and 288 tells us what legal acts the EU itself. So the treaties are concluded by the member states, but 288 tells us what legal acts actually the EU institutions themselves can adopt. And there we see that to exercise the union competences, the institutions shall adopt regulations, directives, decisions, recommendations, and opinions, and we find more detail about them later, like in the subsequent paragraphs. And obviously the most important ones are the regulation and the directive. Decisions are also binding, so they can be important. The other ones are just like recommendations and opinions. They're not binding, so they don't play that big of a role. Right. So these are like the secondary law acts, and then we have tertiary law, because those are also not that important. But these are basically delegated acts. So in secondary law, the Commission can be delegated certain powers to adopt like certain rules. Usually those are rules that are like that define more like go into more detail and more define in more detail like the provisions of the secondary law. So for example, certain obligations that companies have in like certain sectors that are very specific. Right. But we'll just stay on the surface. We'll look at primary law and secondary law. And what I'm trying to show here is that we have this pyramid, and this pyramid suggests hierarchy. So there is a hierarchy going from the top to basically the bottom. And hierarchy means that the lower levels of EU law shall not like contradict or can't go against the higher levels, so like in any national legal order. And what happens, for example, if secondary law, like a regulation, violates the treaties? So, the treaties define the competences of the European Union. And now, let's say a regulation is outside of those competences. So the EU, the Parliament and the Council, they adopt a regulation which is not within the EU competences. Well, that basically contradicts the primary law. So what happens in those cases? Well, like in any jurisdiction, we have a court, or we have courts, and we have the highest court, the ECJ. And the ECJ can basically invalidate secondary law and also tertiary law. And this is, mentioned in Article 19, Treaty on European Union. Because in Article 19, it says that basically the ECJ can invalidate any acts of the institutions of the EU. So that means especially like secondary law and tertiary law. And it can't invalidate the treaties, like any constitutional court can't invalidate the constitution. It can only interpret the treaties, because also in the end, the ECJ gets its competence to interpret EU law from the treaties. So it can interpret primary law and it can invalidate secondary law. And the way we do that is through a procedure that is regulated in 263 Treaty on the Functioning of the European Union. So there, certain actors can like ask the ECJ to invalidate a secondary law act. And also we have this procedure for preliminary ruling in which the ECJ also can interpret EU law and also could invalidate like a secondary law act. Right. So I'm just trying to show you that basically the EU law order is like any national legal order, and there's also like hierarchy between those different levels of EU law. Now, I'll compare this to a national legal order, and because I'm German, I'm going to compare it to the German national legal order. This is also just like a broad overview, like there's more detailed things, obviously. But this is basically the same in any national legal order. So usually in national legal orders of the EU member states, you have a constitution, and then you have laws passed by parliament. And then you might have lower levels, like, for example, government regulations that are usually like, so in Germany, for example, the parliament can give the government certain competences to pass certain government regulations. And then you might also have like things passed by the local administration, which obviously are even lower. And right. So, and in these national legal orders, you have the same thing, right? You also have hierarchy. So you have a hierarchy from top to bottom, and obviously the parliament, the acts of parliament can't violate the constitution. And obviously the government regulations can't violate either the constitution, obviously, but also they can't violate like the parliamentary laws. And in Germany, then we also have the law of the federal states, which can't violate the law of the, the main state, the main federal German state. But that's like too much detail now. And like most legal orders, you have a constitutional court, which, enforces the hierarchy. So you can ask the German Constitutional Court, for example, or like most constitutional courts, to invalidate, for example, a parliamentary law if it conflicts, if it is in conflict with the constitution, for example, if it violates fundamental rights. And you can do the same for government regulations. Now, this might be different in different national legal orders, like in some legal orders. Lower courts are also capable of invalidating laws that, for example, conflict with parliamentary laws, like government acts which conflict parliamentary laws. In some legislations, this might only be the task of the Constitutional Court, but in general, you have at least like you have You have the courts, and you have the highest court, the constitutional court, which will like enforce the hierarchy in the national legal order, which will enforce the hierarchy of the constitution. Right. So what I'm trying to show here is the EU legal order is basically the same as the national legal order. So you have two legal orders that are kind of next to each other and that interact with each other, as we've seen since the ECJ has basically said that the EU legal order can like influence the national legal order, can like be applied within the member states and give rights and obligations to individuals. So now if we have this interaction, we need to basically define how the relationship is between EU law and national law. So what is there a hierarchy? Like, is EU law higher? Is it like the top of the pyramid? Or is it something else? And this is kind of unclear, but it is mostly agreed on that the ECJ has basically, as we've talked about, defined primacy, the primacy of EU law in a way that means that the EU law is not like more important or like hierarchically more important than the national legal order, but it kind of sits on the side and it can disapply the national legal order. Like it can push aside the national legal order and only apply itself. So that is basically what primacy means. Primacy doesn't mean hierarchy. So the EU law is not like above the national legal order and above the national constitutions. But in certain cases, if there is a conflict between national law, the national legal order, and EU law, the EU legal order, the EU law will basically push aside, this is what I'm trying to signify here with this slide, will basically push aside the whole national legal order, and you will only apply EU law. So you could argue that the effect is the same as like hierarchy because EU law wins, but there are some differences because primacy, we'll talk about this now, only applies like in individual cases and it doesn't invalidate national law, which is, you know, what hierarchy does. In a hierarchical system, you know, a parliamentary law, for example, which violates the constitution will be invalidated. So it will be like gone. Right. So we'll talk about that in a second, like the exact differences between hierarchy and primacy, but I think you kind of get the idea. But to go into more detail, we'll now look at more ECJ cases in which the ECJ goes into more detail defining primacy. So one of those cases is E.N.E.L, a case from 77 or from 78, the decision. And in this decision, the ECJ defines what primacy or precedence exactly means. So the ECJ says that a national court, and this decision focuses on national courts, but the same applies for like national administration, that a national court, which is called upon within the limits of its jurisdiction to apply provisions of community law, like provisions of EU law. So this is the first requirement, like the court actually has to have the obligation to apply like provisions of community law in this case. So where community law does not apply, obviously also primacy does not apply, is under a duty to give full effect to those provisions. Like you might know this, E.N.E.L, like the full, like most full effect of EU law, to give full effect to those provisions if necessary, and this is the important part. If necessary, refusing of its own motion to apply any conflicting provision of national legislation. So it must disapply. Disapply is maybe a better word than saying refusing to apply. Disapply. It must disapply any conflicting provision of national legislation, even if adopted subsequently. So this is like a reference to, you know, kind of the Costa case. So no lex posterior. And it is not necessary for the court to request or await the prior setting aside of such provision by legislative or other constitutional means. So this is also what makes primacy different from hierarchy, because when we look at hierarchy, we need to wait and to request, for example, the Constitutional Court we have to ask the Constitutional Court to invalidate a law, like a parliamentary law which is in conflict with the Constitution. We have to ask the Constitutional Court to invalidate that law. And basically the ECJ says this is not true for EU law. So the National Court can, of its own motion, without asking the Constitutional Court, any national court, even the lower courts, can, of their own motion, disapply national law which is in conflict with EU law, even if that law is adopted subsequently. And also notice that the ECJ does not differentiate between different legal acts, national legal acts. So this could be talking about national constitutions, which we'll get into. This could be talking about parliamentary laws. This could be talking about government regulations or even lower decisions of the administration. Basically, the ECJ says national courts and national administrations must disapply any national law which conflicts with EU law if they are asked in a certain case to apply community law, right? And they must not wait for or request, for example, their Constitutional Court to invalidate the national law or to decide on this issue, right? So for the ECJ, there's three things that follow from primacy. We'll look at two things now. One thing we've just talked about, which is the disapplication of national law in a conflict. But there's one thing that comes before disapplication, which is interpretation. And this also follows for the ECJ from the principle of primacy. So the first thing we can define as primacy of EU law is that national law, if EU law is to be applied in a case, that is obviously the first requirement. So in areas where the EU doesn't have competences, there's no EU law in those areas, then obviously we can't refer to EU law, and then we don't have primacy. But if we have such a case where we have to apply community law, then the first step is that we must always, at least in general, apply national law, interpret in national law in accordance with EU law, right? So if EU law says one thing and the national law says kind of another thing, but you can interpret it without going against the wording of the provision, then we have to interpret the national law in accordance with the EU law provision. Now, if possible, if the ECJ says you can't interpret, and this is a general rule of a general legal rule, you can't go against the wording, contra legem, you can't go against the wording of a provision. So in that case where you can't interpret the national provision in accordance with EU law, the second principle of primacy applies, which is what we mostly know as primacy, the disapplication of the national law. So in this individual case, if we can't interpret the national law in accordance with EU law, we have to disapply, we have to not apply the national provision. But, and this is what is different from hierarchy, this national provision remains valid. It's not invalidated. So for future cases, this national provision is still valid. But for this individual case, the decision before the court or administration, the national law is not applied. And it is pushed aside, and only the EU law act is applied. Only the EU law provision is applied. And this also means, and this is also a stark difference to hierarchy, that EU law never invalidates national law. So this is what I meant when I said there's no hierarchy. So the ECJ doesn't have the competence to rule on national law. It's not in a treaty. The ECJ never rules on national law questions. It never invalidates national law. It never interprets national law. It only interprets EU law. So EU law never invalidates national law, but it does something which in the individual case has the same result, because it disapplies national law in the individual case, and so the individual case is decided as if there were no national law, right? So, and we're also not talking about like national law as a whole. We're only talking about like the individual provisions, right? So we can disapply national law on a provision by provision basis. We don't have to disapply like a whole, a whole law or something like that, right? So I want to summarize this basically in one slide, what hierarchy is and what primacy is, because I think this is quite important to understand, because it's like the founding principle, I would say, of EU law. So hierarchy means, as we've seen with the pyramid and with the constitutional courts in the national legal orders, that conflicting laws and, government orders or something are invalidated. Usually this is done by the constitutional court. It might also be able to be done by lower courts, but the law is invalidated. It's no longer valid for no cases. For no cases before like administration or courts. Hierarchy usually applies, as we've seen, within one legal order. It applies within the national legal order. It also applies within the EU legal order, but it applies within one legal order. But now we're talking about the relationship between two legal orders, and there we could have hierarchy. In theory, it would be possible to say that EU law has hierarchy, but it wouldn't make sense because, as I said, the conflict or like the touching of those two legal orders only appears or is only there in certain cases, certain subjects, certain like areas of competency. So in that case, we have primacy, and this again means that the national law is displaced in the individual case, but it stays valid either if we don't have a conflict, like, for example, as I said, maybe we can interpret the national law in accordance with EU law, or we have an area where EU law doesn't apply at all, and then obviously we don't have a conflict, and then we just apply the national law, right? So this is what the relationship between EU law and national law means. And again, as I said, primacy, and this is kind of tricky maybe to understand, and it's also not super clear in ECJ jurisprudence, but it has become more clear. Primacy does not only mean disapplication of national law, but primacy of EU law actually means several things. And the first thing that it always means is that you have to interpret your national law in accordance with EU law, where you have like application of EU law. So maybe you don't have to disapply national law if you can avoid the conflict by interpreting your national law in accordance with EU law. If that's not possible, then you have like what we know more as primacy. You have the disapplication of national law. And then you also have another aspect which we'll get into, which is the Frankovic jurisprudence of the ECJ, which is that you might have you might be able to demand damages from your state if in a certain case you get damages because your state has not fulfilled an obligation from EU law, but we'll look at that. But so just remember, primacy has several elements, and the most two important elements are interpretation according to EU law, and if that is not possible, because interpretation would be contra legem, then maybe disapplication of national law. And we'll look into what exactly are the requirements for disapplying national law, right? And this is actually what we'll do now. So now we'll look at what the actual requirements are for us to disapply national law. So if we are the national administration or we are the national judge, when do we actually disapply national law and apply EU law? And most of these we get from E.N.E.L, but there's an additional one that we'll have to talk about. But first of all, well, what is the first one? Well, the case falls, our individual case that we have to decide, falls under the scope of EU law. So again, as I said, if we don't have to apply EU law in this case because there is no EU law, because the EU doesn't have a competence in this regard. Then obviously there's no primacy and there's also no disapplication of national law. The second one is, as the ECJ said, is a conflict. So we need a conflict between a national law provision and an EU law provision. If we don't have that conflict, then we can just apply the national law. Like, for example, if a directive has been fully implemented into national law, we'll just apply the national law. There's no conflict. There's no problem. Now, whether we have a conflict, this might be a bit complicated, but I think you get the point. If we have a conflict, also depends on the harmonization level. So EU law, but especially directives, this is especially the case for directives, can have different levels of harmonization. So we have minimum harmonization EU law acts. This is mostly an issue for directives, as I said. So basically, if our directive is minimally harmonizing, then it says that member states have to provide a certain standard, of protection. For example, let's think about a consumer right case. The consumer right case, the Consumer Rights Directive might say that, member states have to provide at least an obligation to at least provide repairs for a product for 2 years. But the directive might say that member states can implement longer periods. They can give more protection. They can give better protection. Or right to withdrawal. You could say minimum 14 days, but if a member state wants to give somebody 5 weeks to withdraw from a contract, they could do that. So it's important to understand that if the EU law only gives us a minimum standard of protection, then this is kind of obvious, but then if the national law offers more protection, better protection, then there's no conflict. You might have a conflict in the text because one thing says at least 14 days and one thing says 4 weeks, but this is not actually technically a conflict because, it doesn't go against the wording of the directive. Now, this is different if we have fully harmonizing EU law acts like most regulations are, and more directives also are. This means that basically member states cannot deviate in any way. So in that case, the EU would say, well, the right to withdrawal only exists for 14 days and member states may not deviate from this provision. So, or it may not be textually in the provision, but it might be clear from the interpretation of the provision that it is supposed to be fully harmonizing. And then any deviation, whether it be better protection or less protection, for example, from in consumer rights, would be a conflict, right? So we always have to remember, do we actually have a conflict? This is very important. And now, we have one more step before we would disapply national law. As I said, primacy is not only disapplication, but it's also interpretation. So the first thing we have to do to resolve a conflict is we have to interpret the national law in conformity with the EU law. So if our national law says that there is a right to withdrawal, but it doesn't specify how long, and the EU provision says right to withdrawal is 14 days, then we can read the national law provision as right to withdrawal for 14 days. We can interpret that into the provision. So then our conflict is avoided. We don't have to disapply national law. We just apply the national law. But if, our national law is very clear, like it says right to withdrawal 7 days, and the EU law says right to withdrawal 14 days, well, then we can't interpret 7 days as 14 days. So interpretation in accordance with EU law is not possible. So then we have to disapply national law. If, and this is one more thing, because we're always talking about an individual case. So there's one more requirement, which is not super clear from ECJ legislation, jurisprudence, but which does make sense, which is that the EU law has to have direct effect in the case at hand. Now we'll talk about what direct effect means, but basically it means that the provision of EU law, that's not only scope of EU law, but actually the one provision that I want to, for example, get my claim from, has to be able to be applied in this individual case by the court or the administration. And we'll talk about what that means, but basically it means that the provision must be clear enough that I can actually invoke it in a national law case, and that, there's a clear and precise legal consequence stemming from that EU law provision. Because if the EU law provision doesn't give me like a clear legal consequence, well, then I can't apply it in my case, because it won't get me to like a legal result. And then also I can't disapply national law, because in that case, if I can't apply the EU law provision and I disapply the national provision, then I have no law governing the case. So it doesn't work. But we'll talk about in a second in more detail what that means, because I think direct effect is quite complicated. And it's also quite complicated to think of it as like a requirement for disapplying national law, right? So, right. So if we have all these requirements, then we have primacy of EU law in the sense that the national court or national administration will disapply the national provision and will only apply EU law, the EU law provision to this case, right? Okay. So this is what the ECJ says in general. This is what primacy of European Union law means. So primacy again means we'll interpret if we have scope of EU law and we have a conflict between EU law and the national provision, we will try to interpret the national provision in accordance with EU law. And if we can't interpret in accordance with EU law, because it would be contra legem, and the EU provision actually has direct effect in this case, then we disapply national law and we apply EU law. And we directly, for example, invoke the regulation or maybe the directive or maybe the treaty provision that gives us a certain claim, for example, or gives us a certain right. Okay. So now you might already see why this could be a conflict, because this basically means that the national legislator has, or maybe even the constitution, has some principle, some national law principle, and now the EU comes, like the EU law comes and disapplies that national law and says, now we only apply EU law. So this can obviously be a conflict. And it is especially a conflict between the ECJ and the constitutional courts. And we'll get to this conflict in a second and how it is resolved. I just want to make one thing clear. When we talk about EU law, like we often talk about, this might be political, but we often talk about like the EU as this like organization that gives us like regulations that say like a certain thing and that go in against like national interest. But when we talk about conflict of EU law and national law, we always have to remember that the EU acts only within the competences conferred to her, like conferred to the Union by the member states. So the member states decide in the treaties which competence they give the EU. And then if we talk about EU legal acts, which we'll see in a second, like regulations or directives, we have to remember that those EU legal acts are adopted by the parliament, which is, directly elected by the citizens, and also by the council. And within the council, in order to adopt a legal act, you need like a 55% majority, and also this needs to cover 65% of the citizens of the member states. So we just have to remember that when we talk about EU law, member state, it's not like this independent organization completely void of responsibility or supervision. It's actually the parliament and the member states and the council that, be it by majority, that is obviously an issue, but that pass these legal acts. All right. Now, when we talk about primacy and the conflict between the ECJ and constitutional courts, the main question is not whether, you know, EU law has primacy over some parliamentary law. This is in general accepted by the Constitutional Court. So the Constitutional Courts don't really have an issue. Mostly, there are some really extreme cases, Poland, but mostly don't have like a problem with primacy over national laws, like national parliamentary laws or like government regulations. They mostly have an issue with the question, does EU law even have primacy, even over the national constitutions? And this is obviously a key issue for a constitutional court, because, for example, if we look at the German Constitutional Court, well, who interprets the national constitution? The Constitutional Court. So who has the final say about what the constitution means? The National Court. So what happens if the National Constitutional Court, just so you understand the issue, what happens if the Constitutional Court accepts primacy of EU law over the national constitution? Well, who interprets EU law? The ECJ. So if we accept primacy over our national constitution, we accept that the ECJ might interpret EU law in a way that maybe goes against our constitution, but then EU law takes primacy over the constitution. So in a certain case, and this means all cases where our constitution is applied and there is like also EU law governing the case, we disapply a provision of our constitution. So this is like tricky in two senses. The first sense, obviously, that, you know, the constitution is something nations hold very dear and they don't want to lose like the sovereignty in the sense that something else triumphs over their constitution. But it also is a power struggle for constitutional courts, because when they accept primacy, they accept that basically like a higher court, the ECJ, interprets EU law that then takes primacy over their constitution. Right. So it is no surprise that when you ask the ECJ whether EU law takes primacy over the national constitutions, the ECJ says yes. So there's this case already from the 70s, Internationale Handelsgesellschaft, finally a name I can pronounce. And here the ECJ makes clear what it already said in Costa and what it will later say in E.N.E.L. You know, it says the validity of a community measure or is its effect, I misspelled there, its effect within a member state cannot be affected by allegations that it runs counter to either fundamental rights as formulated by the constitution of that state or the principles of a national constitutional structure. So basically, this means that EU law takes primacy over the national constitutions and even the principles of national constitutional structure. So like fundamental constitutional principles, and we'll get into that. And also fundamental rights as formulated by the constitution. So this goes really, really far. It says primacy over everything, over the whole national legal order, including the constitution, including fundamental rights. And this became very relevant in a case that, is also quite important. This was a case out of 2011, which is called Meloni. And Meloni is a very important case for primacy and fundamental rights. So Meloni was an Italian citizen, and Meloni was basically given like a criminal punishment, like a jail term, in Italy by an Italian court, but in absentia. So he was not there. Like he didn't show to his trial, and he was basically given like the jail term without being there. So because Meloni had actually fled to Spain. And there's something called an European arrest warrant. So if you're looking for somebody, you can like basically put up an arrest warrant in the EU, and you can say, well, if you find this guy, please send him to us so we can like impose our jail sentence. And so now the question was, he was picked up in Spain, and the question was, will the Spanish courts, will they actually extradite Meloni to Italy? Because, and this was the question before the Spanish Constitutional Court, the Spanish Constitutional Court held in the past that basically the Spanish Constitution guarantees the right to a trial with you being present. So you can't be criminally punished without you being present during the trial. And so basically the Spanish Constitutional Court said that they can't extradite in principle because Italy does not guarantee a new trial with Meloni being present. So the Constitutional Court then, asked the ECJ, and the ECJ said, no, we have to uniformly apply this European arrest warrant. So this EU legal act that the arrest warrant is based on. And if we look at the, European Charter of Fundamental Rights, there's no right to like a trial in presence, at least not in the way that the ECJ, read the charter. And we can't allow, even though there's this provision, Article 52 or like 51, I'm not sure, which kind of allows member states to have their own constitutional fundamental rights. We can't allow national, the member states and the member states' constitutions to basically say that they can't apply a legal act, an EU legal act, because of fundamental right issues in their national constitution. But EU law has to take primacy even over the fundamental rights in the Constitution, even if those fundamental rights of the Constitution guarantee a higher fundamental rights protection standard than the EU Charter of Fundamental Rights. Because again, obviously from the perspective of the ECJ, this makes sense because the only way to uniformly apply national law is to take primacy over everything. And if we allow national states to not apply EU law based on fundamental rights, then again, basically any member state has like a cop-out to, broadly interpret their fundamental rights in a way that, endangers the uniform application of EU law and therefore endangers the idea of the, common market and the harmonized EU law, right? Now, the member states are not so quick, like the member states' constitutional courts are not so quick to accept primacy, especially not over their constitutions. So this kind of started with the German Constitutional Court. So the constitutional courts have generally accepted primacy, but with some exceptions. And, I'm German, so I will mostly show you like the German jurisprudence, but we'll look at the Estonia example later because as I said, like this was in a presentation for like Estonia. So generally, member state constitutional courts have accepted primacy, but with some exceptions. And these exceptions in Germany, for example, are that the German court has over the years accepted primacy unless one of three things is the case. So in the beginning, there was a problem with like fundamental right protection on the EU level because there was no Charter of Fundamental Rights and the ECJ hadn't already, guaranteed fundamental rights as like general principles of EU law. So the German Constitutional Court said, well, as long as the EU does not provide like a protection standard for fundamental rights, which is equal or at least generally equal to our constitution, then we will actually not accept primacy. We will check EU law acts and we will reserve the right to basically disapply EU law. We will reserve the right to not accept pushing aside the disapplication of our national law. This is obviously a huge issue because the ECJ says primacy always, and the German Constitutional Court said no, we reserve the right not to apply EU law. You can see how this is obviously a conflict when it comes to, applying EU law equally in all the member states. Now, the German court later accepted that in general the EU provides an adequate protection of fundamental rights, and it said, well, as long as this is the case, that's why it's called so lange, as long as the EU does provide an adequate standard in general, we will not check EU law acts anymore. And even if now in one case, like Meloni, the protection of the basic law, like the German constitution, is higher, we will still accept primacy, like in singular cases, but not like in general that that there is like a lower standard of protection of fundamental rights. All right. The second thing they said, and this actually makes some sense. I'm not here to judge. I'm just trying to like show. They said, well, we only accept primacy if the EU does not act outside its conferred competences. So the competences conferred to the EU in the treaties. And this was actually a decision about the European Central Bank buying bonds from states during the financial crisis, and the ECJ held in a judgment that this program of the European Central Bank was valid, like it was in conformity with EU law. And the German Constitutional Court said, well, actually it wasn't. Like the interpretation given by the ECJ is so ridiculous that the ECJ actually acted outside the competences that it has according to Article 19 TEU. So basically the German Constitutional Court said, no, the ECJ acted without the competences conferred by the treaties, and so this decision basically doesn't apply. So this is kind of the power struggle. You see, the German Constitutional Court says, well, EU, you only get your competences because we allow it, because our constitution allows Germany or allows member states, to transfer competences to the EU, to you, that you can enact. But you have to stay within those competences because otherwise you lose the support of our constitution, basically. And then the third thing is, this is Lissabon. EU law has to respect the constitutional identity of the German constitution. So fundamental principles, of the constitution, like democracy, rule of law, things like that are important to a democratic state. And this is actually the one that is most broad, because anything could be a constitutional identity principle. Like you could make anything part of your constitutional identity. And this is actually what most constitutional courts kind of do. Like they reserve this constitutional identity as something that has to be reserved and kind of protected from primacy of EU law. So it's not fully clear, the German Constitutional Court has said that some things are constitutional identity, but it is not fully clear what encompasses constitutional identity, and you could actually add some things. So some countries are stricter. For example, there's a decision from the Polish Constitutional Court which goes very far against primacy. You can read it if you want, but basically it says that this primacy as held by the ECJ, even over national constitutions, is not cannot be applied at all. And now we'll look at the case of Estonia, like how the Estonian Constitutional Court has kind of accepted primacy. Well, first of all, because again, as I said, this was an Estonian presentation, but also because I think it's quite telling. It shows very nicely how the jurisprudence of the constitutional courts with regards to primacy has evolved. So if we look at Estonia, then when Estonia joined the European Union in 2003, they adopted a constitutional amendment, so a law that changed the constitution, which is this act, which I will not try to pronounce. This law basically says, well, Estonia may belong to the European Union. And now the phrase proceeding from the fundamental rights of the Constitution, or in some translations, it's also according to the fundamental rights, the fundamental principles of the Constitution. And now the one which is more broad says, well, upon Estonia's membership in the European Union, the Constitution of the Republic of Estonia shall be applied, taking into account the rights and obligations arising from the Treaty of Accession. So, you can only apply the Constitution taking into account the obligations from the treaties, from the accession treaties and the fundamental treaties. And so the Estonian Constitutional Court, the Riigikohus, was asked in 2006 whether Estonia could join the Eurozone. And the problem is that there's like a provision in the Estonian constitution which says, I think it's 116, which says that only the Estonian central bank may issue currency. Now, obviously, once you join the Eurozone, the currency politics is done by the European Central Bank. You can still print currency, but the currency is basically decided on by the European Central Bank, and also, like the policy. So the question was, can we enter the Eurozone even though our constitution says only the Estonian Central Bank can issue currency? And the Estonian Constitutional Court held that, in the substantive sense, this amendment is a material amendment of the entirety of the Constitution to the extent that the Constitution of Estonia is not compatible with the European Union law. And it says, well, that means that only that part of the Constitution is applicable in cases which is in conformity with the European law. And those provisions of the Constitution of Estonia that are not compatible with European Union law are suspended. So we don't apply our national constitution. And this means, and this is the important part, they basically took from ECJ jurisprudence, this means that the European Union law shall apply in the case of a conflict between Estonian legislation, including the constitution, with the European Union law. So this means unlimited primacy of EU law over all Estonian legislation, including a constitution. So this is like the most EU-friendly constitutional court position you could take. Basically, we say we accept unlimited primacy over our constitution. We accept unlimited primacy in the sense that the ECJ can interpret EU law, and we disapply any constitutional provision of our national constitution which is in conflict with EU law. So obviously this was, they were excited to enter the EU, so this was a very positive, a very EU-friendly approach. Now, they changed that, as did a lot of constitutional courts, because they might have realized that this basically gives them no power anymore. This gives them no possibility to say, in a certain case now, we kind of have constitutional values that we want to protect. So that's why they changed the jurisprudence in 2022, like a lot of constitutional courts did. And they said, well, we only read Article 2, Paragraph 2 of the law. We also have to read Paragraph 1, which said fundamental principles. So they said, well, under Paragraph 1 of this law, of the constitutional amendment, Estonia may belong to the European Union proceeding from the fundamental principles of the Constitution. Thus, and this makes it very clear, the principle of primacy of EU law applies to the entirety of Estonian national law, including the Constitution, but only insofar as this is not contrary to fundamental constitutional principles. So now they have the reservation like the German Constitutional Court has, like the French Constitutional Court has. They now have the reservation of fundamental constitutional principles, and this is obviously a broad term. So you could basically, any value that is in your constitution could be a fundamental constitutional principle, and you reserve the right to basically say, no, EU, this goes too far, right? So they started with a very friendly primacy position, but then they changed it to basically match that of most constitutional courts, which has this reservation for fundamental constitutional principles. Okay, this is basically all I wanted to show you about primacy. We'll talk more about like the requirements of primacy, but this is what I wanted to show you about like primacy and the conflict between the ECJ and constitutional courts, which keeps on, evolving. And obviously, it also depends on the political climate. You've seen that in Poland. So obviously, if you have governments and judges that are more anti-EU, you will get more like of the jurisprudence that reserves rights and doesn't accept primacy. And on the other side, you have the ECJ, which says, primacy overall, right? Okay. So now that we've like checked primacy, I want to look with you at the EU legal order in more detail. And we've already seen this like pyramid, primary law, secondary law, tertiary law. We've seen hierarchy. We've seen that like the ECJ can invalidate a secondary law act if it is in conflict with primary law, right? Through the procedure 263 TFEU. And now I want to kind of shortly look into more detail on what primary law actually is. So primary law, as we've seen, is the foundational treaties and their annexes and protocols and the Charter of Fundamental Rights. So really primary law, as I said, is the constitutional layer, but we don't call it a constitution because, they tried to adopt a constitution which was not ratified. So primary law is, first of all, the Treaty on European Union, TEU, which has most of the basic provisions. So we have values of the EU, democracy, rule of law. Then we have the National Identity Clause, which says EU has to respect the national identity. E.N.E.L, and the general rules on competence, so the principle of conferral, competences have to be conferred to the EU. The EU has to act like according to subsidiarity, proportionality, and then we have the basic rules on the institutions. So what is the Parliament? What is the Council? What is the Council? The European Council, stuff like that. And then we have more details in the Treaty on the Functioning of the EU. So we have the competences, the actual competency provisions. We have the 4 economic freedoms. We have rules on citizenships, the legal acts we've seen in 288, and obviously all of the ECJ proceedings. So there you see CFEU. So CFEU encompasses both the court of the EU and the ECJ. There's like 2 courts, and the ECJ is the higher one. Right. Then we also have the Charter of Fundamental Rights, which has the status of primary law in Article 6 TEU, as I explained. We have general principles of EU law that kind of like the ECJ thought of. These are also things like rule of law and stuff like that. And we have the protocols and annexes to the treaties, and also the accession treaties are part of primary law. Now, this will get into more. So I will just show you this for now. Provisions of primary law can have direct effect. So we'll talk about what that means, but not all provisions of primary law have a direct effect in cases, before national courts and administrations. Right. So now we'll look at the most important legal act of the EU, which is the regulation. So the regulation is in 288, paragraph 2 of the Treaty on the Functioning of the EU, and we'll actually for a second read what it says in that provision. Because paragraph 2 reads, a regulation shall have general application. It shall be binding in its entirety and directly applicable in all member states. So there's 3 things basically. The regulation has general application, it's binding in its entirety, and it's directly applicable in all member states. So what does this actually mean? Well, the regulation is the main legal act of the EU to harmonize the law in the member states, and for these reasons, which are: it has general application. So that means it's not addressed to like a certain individual, like a decision. It's not addressed to the member states. It's addressed to everybody. So it can, right? We've already talked about right and obligations. Like it's addressed to any individual, any company, any natural person, any judicial person, all the states, everybody, right? It's binding in its entirety. So that makes it hard because member states can't adapt. So that makes it good for harmonization because member states cannot deviate unless there is an opening clause in the regulation which allows states to change something. And this is what is in the second sentence, it is directly applicable in all member states. And directly applicable, direct application of EU law means basically that the EU Law Act is valid in the national legal order without implementation through national law. So you don't need, like the international law thing I talked about in the beginning, a national legal act which transposes the EU law into the national legislation. And actually it's not even allowed. So in general, member states are not even allowed to transpose, like to implement regulations into national law, because the ECJ says, well, if they do that, it could kind of conflict with the idea of a regulation, because then the states could act like it's national law, and like maybe the Constitutional Court can interpret it, but the ECJ says no, it has to be directly applied as EU law, so it is clear, that it takes primacy, that the ECJ is the only one to like really decide on its interpretation, right? So this is as I explained, this is one of the main features of the EU as a supranational organization, which is that it can make legal acts, it can make laws, it can implement laws, which are immediately part of the national legal order. And this is basically what directly applicable means. It's immediately part of the national legal order once it is adopted on EU level, right? And the next thing that we have to kind of differentiate from direct applicability, but which goes into like the same direction, is direct effect. And we'll talk about what that means, but just remember for now that regulations have direct effect in general, and they have vertical and horizontal direct effect. I'll get to what that means in a second. And which I also already talked about is that regulations are adopted through, in general, the ordinary legislative procedure. That depends on like the rule, the provision of the TFEU, because sometimes it says that there's a special legislative procedure, but in general, it is adopted through the ordinary legislative procedure, and the ordinary legislative procedure, according to 289 and 294 TFEU, means that it is adopted by the Parliament through a simple majority and the Council through a qualified majority, which is this majority of 55% of member states and 65% of the population, which has to be represented by those member states. And one more important thing, which you may know about legislative procedure in the EU, is that EU law acts can only be passed on the initiative of the Commission. So unlike most national parliaments, the EU Parliament does not have the right to initiative, so it does not have the right to propose legislation. The legislation can only be proposed by the Commission, and then it is adopted by the Parliament and the Council together in the ordinary legislative procedure, which is simple majority in the Parliament, qualified majority in the Council, and the Council is where all the member states are represented by the ministers. Right. So the next thing we'll look at is directives. So directives are regulated in Article 288 paragraph 3, which we'll look at for a second here. And it says a directive shall be binding as to the result to be achieved upon each member state to which it is addressed, but shall leave to the national authorities the choice of form and methods. Right? So we'll look at what that means for the directive. Well, the directive can basically harmonize member state law while preserving more of the member state's identity, because it allows the adoption and basically the member states to change things about it. So in principle, it has no general application. This was the first thing we talked about with the regulation, because it isn't applied. It doesn't apply to everybody. It is only addressed to the member state. So the member state has the choice how it implements, because also the directive, as it says, it's only binding in its intended result. So you have to achieve the result that the directive gives you, but the member states can decide how they implement it into national law, through which legal act, and how, what they allow for harmonization. If the EU law act is maybe only minimally harmonizing, they can give a higher protection of standard. And basically they have more control because they make an act of national legislation, like a law, and they have obviously more control on how that looks, how it reads, and stuff like that. Right? Also, because of this, the directive is obviously not directly applicable, because it doesn't apply in all the member states directly from its implementation. But the states have to implement it into national legislation, and that requires obviously that the member states actually do that. And if they don't, then that doesn't mean that now actually the directive is suddenly applicable in the member states, because it isn't. It needs the national adoption through national law. So member states need to make a national law. This has to be like formal. It has to formally implement the directive. It also means that they actually have to materially implement what it says in the directive. It has to be practically efficient, like it actually has to implement what the directive says. But if the state doesn't want to implement, you can't really force them. Like there's no EU police that will come and arrest somebody for not implementing the directive. So basically the only thing the EU can do, this is possible, either the Commission can do this or another member state, they can launch an infringement procedure. So it is an infringement of the treaties, more specifically of Article 288 TFEU, not to implement directives. So they can sue the member state, and then the ECJ will say, well, member state, you violated your obligations from the treaties. So basically you have to implement. And then there is a second procedure in front of the ECJ by which the Commission can actually sue for the ECJ to give the member state a fine, like they have to pay a certain amount per day, for example, while they don't implement. But they can't really force their hand to implement the directive. And the second thing that I already mentioned quickly in the beginning is Frankovic. So the ECJ decided that, well, if your national state doesn't implement something like a directive, and you get damages from that, for example, you don't get your right to withdrawal, or you don't get your 2-year guarantee on your newly bought smartphone, and you get damages from that because now you have you can't invoke a certain right, for example, then you can sue the state under the Frankovic criteria. And one of those criteria is that the state has not implemented the directive, and then you can actually get damages from the state for the failure to implement. But again, this doesn't force the state to implement. Right. And because of this, because basically the regulation is not directly applicable and it has to be transposed into national law, it also doesn't have direct effect. So we'll talk about that in a second, but that means that you can't directly invoke a directive provision in front of the national court if it hasn't been implemented, because it needs to be implemented. And again, the directive also is adopted by the Parliament and the Council through the ordinary legislative procedure. And this is just as a side info, whether the EU can adopt a regulation or they can adopt a directive is usually specified in the TFEU treaty provision. So, for example, there's Article 53, I think, of the TFEU, which only allows for the adoption only the adoption of a directive, but not of a regulation. If there's no provision on that, the EU can then decide if they want to do a regulation or a directive. Right. Okay. And now, bear with me because we need to talk about one more thing, which is direct effect. So I've mentioned direct effect several times now, and the important reason why we have to talk about direct effect is that in order to disapply a national law in a certain legal case in front of a national court or in front of national administration, we need to be able to apply the provision of EU law that we want to disapply national law. So in order to do that, this EU law provision needs to have direct effect. So I showed you this on this slide, right? We need to have a case an individual case which falls under the scope of EU law. So there is some EU law that is generally applicable in this regard. Then we need a conflict between EU law and the national law, which depends on the level of harmonization and the level of adaptability that the member states have. Then, if that conflict is actually there, we need to try to resolve it through interpretation. This is one of the principles of primacy. We need to try to interpret the national law in conformity with EU law. And only if this is not possible, because it would go against the wording or there is just no national provision we could really apply, then we can apply EU law. But we can only apply EU law in this case if actually a provision has direct effect, which means that it is clear enough, precise enough to apply it in this case, right? And only then, if those requirements are fulfilled, we have primacy in the way that we actually disapply the national law and only apply national EU law to that case, right? Now, to understand direct effect, I want to kind of talk about both words that are in the treaties, or both of these meanings. One of them we already talked about, which is direct applicability. If you remember, this is actually in 288 paragraph 2. So it says that the regulation is directly applicable in all member states. And we have to differentiate that from direct effect, which I just talked about, and which is one of the requirements for primacy. Right? So direct applicability is just what it says in the regulation. Direct applicability means that the regulation, but also other parts of EU law, are part of the national legal order without the need for implementation. So basically, it is what the ECJ established in Van Genderen Loos. These EU legal acts are part of the national legal order without the need for transposition, without the need for implementation through national legislation, right? So this applies to the regulation because it says so in the treaty, but it also applies to the treaties because the treaties are EU law that is applicable in the member states. It also applies, for example, to the Charter of Fundamental Rights, which is also applicable in the member states. So I can rely on the Charter of Fundamental Rights. It also applies to decisions. It does not apply to the directive because the important thing about the directive is it needs to be implemented. So it is not directly applicable when it is announced. Now we have to differentiate that from direct effect, because just because a provision is part of the national legal order does not mean that we can actually apply it in our case, because in order to apply a provision, we need for it to actually produce a legal consequence in our case. And so direct effect describes whether we can actually invoke the provision before a court or administration. So whether it is precise enough that a court or national administration can actually apply this EU provision to the case at hand. Now, sometimes the question is whether it has to give like a right to the individual. We'll talk about that if that is really necessary. But we have to differentiate two cases of direct effect. And the ECJ basically differentiates these two cases, which are vertical direct effect. So vertical means in regards to the state and the individual. So vertical means, can I invoke the provision against the state? Or can the state invoke the provision against me, but that case is denied by the ECJ? So really, the only important vertical case is, can I, as an individual, invoke the provision against the state? And then there's horizontal direct effect. Horizontal because it is like between parties on the same level. So horizontal means, can I, as an individual or as a company, invoke the provision against another private party? So this would usually, horizontal direct effect would be in civil law cases, between like private parties. And vertical direct effect would be like in administrative cases before administrative courts, me against the state, like the state wants to abolish my house or something, like then that would be a vertical case, right? So these two we have to differentiate because the ECJ says that sometimes provisions can have only vertical direct effect, only me against the state, but not horizontal effect, right? Okay. So now that we understood what direct effect actually is, we want to talk about what parts of EU law have direct effect. So which parts of EU law, which EU law provisions can I actually invoke before a court or national administration? And the ECJ has held, also in Frankfurt and Loos, has established certain requirements that a EU law provision has to fulfill in order to have direct effect. And the ECJ rule is that, first of all, the provision needs to be clear and precise. So clear and precise basically means that there has to be some kind of legal consequence that following directly from the provision. Like the provision has to be clear that there is like a certain legal consequence. So either this is like something the state or an individual has to do or mustn't do. So the state mustn't do, for example, a thing that could be a legal consequence following from the provision. So one example of a primary law provision, which the which the ECJ has actually held that it has direct effect, is Article 157 TFEU, and I'll show this to you in a second here. So 157. And this basically says, each member state shall ensure that the principle of equal pay for male and female workers for equal work is applied. So, and then it defines what pay means, and what a wage is, and a salary, and stuff like that. And the ECJ has said this is clear and precise. So the legal requirement that follows from this provision is that men and women are paid equally. And this is something that is so clear, the legal consequence is so precise, that we can directly apply this in front of a national court. The national court can say, do we have equal pay for equal work? No. Because, for example, men and women are paid a different amount per hour for exactly the same work. And then this legal provision is clear enough that that the national judge can actually decide the case based on Articles 157 TFEU. So the question is, can the national judge in this case use this provision to decide the case? Now, an example of a provision from primary law which would not have direct effect, for example, is if we look in the Treaty on European Union, Article 2. It says the Union is founded on the values of respect for human dignity, freedom, democracy, equality, and the rule of law. Well, it says equality in this provision, so we could think about if we can decide our equal pay case in front of the national judge based on Article 2 TEU, but this is like really, really broad. What is equality? Like equality does not give us a clear and precise legal consequence on which basis we can decide the case. It's not clear enough. Now, maybe it could be clear if the ECJ interpreted it, but in general, this is just to show you that the ECJ has held that only certain provisions, which it basically decides, which it classifies, have direct effect, are like clear and precise enough to be invoked, right? So this is an example of like a primary law provision. Now, the second thing is that it has to be unconditional. So the provision itself must not have like any reservations or qualifications in the individual case, which first of all have to be like decided. It is not fully clear, I think, what this like means, but there can't be like a certain reservation that can't be like decided in the individual case. And then the third one, and this is pretty obvious, there must be no further implementing measures required. So this is basically already where the directive fails, but other provisions could also fail. For example, if our primary law provision tells us that the member state has to do something, the member state has to establish an agency, the member state has to adopt a legal act, or even EU institutions have to do something, they have to decide something, they have to adopt a legal act, then the provision can't have direct effect because there is a further measure required. And now the fourth one, which is sometimes classified as a requirement for direct effect, but which is a bit tricky, is that it improves the legal situation of the individual, or that the individual can draw a subjective, like a right from this provision, like a claim. Now, this doesn't always make sense because, of course, if I want to sue my neighbor, like I want a claim for compensation, then if I want to rely on an EU law provision, the legal consequence of this EU law provision must be that I have a claim. So in that sense, yes, it has to give me a right. But you could also have cases where maybe there's no other person involved. So it's just like the administration deciding like whether I can build a house or not. So in that sense, it doesn't have to give me like a subjective right, like a subjective claim. But the ECJ says that in the case where individuals are affected, it has to improve the legal situation of the individual. So usually we can't use it to have negative impact for individuals. But this is also not generally true, because it is not true for regulations, because regulations can give rights and obligations to individuals. And in some cases, the ECJ has even held that primary law can give obligations to individuals. For example, the article we talked about, Article 157, is also applicable according to the ECJ, not only against the state, but also against my employer. So I can sue it is applicable in a case between an individual and their employer. So now, obviously, if the employer loses the case based on Article 157 TFEU, then it worsens the legal situation of the employer. So basically, it's not true that an EU legal provision, in order to have direct effect, always improves the legal situation of an individual, because especially in horizontal law cases, it usually doesn't, at least for one of the individuals, right? So the ECJ has held this for some, like for the economic freedoms mostly, but not for all EU law provisions, especially not for regulations. So regulations generally have direct effect, but if they don't, we can't really test, if we test if a regulation has direct effect, we can't really test this fourth criteria, because the regulation can put obligations on individuals. That is like one of the main things that the regulation does. Okay, so this is mostly related to primary law. So some provisions of primary law where the ECJ has held that they are clear and precise, unconditional, no further implementing measure required, are the economic freedoms. So I can directly invoke economic freedoms, like the freedom to transport goods, the freedom to move to another country and work there, I can directly invoke this in front of a national court. As the same with equal pay, the same with competition law, and the same with the rules on EU citizenship, and also the Charter of Fundamental Rights. So that has also direct effect. So I can actually invoke that in front of a national court. Now, in general, primary law only has vertical direct effect. So I can only invoke it in a case against the state, or, the national administration against the national administration. Then the national administration has to apply this provision. Sometimes the ECJ has held that it can also have horizontal direct effect, like equal pay. But that's the exception. Now, I already talked about regulations. Regulations generally have direct effect, and the ECJ has kind of held that we don't need to check regulations like all the time for direct effect, because it says that by their very nature, they usually have direct effect. So there's some very small exceptions where regulations might not have direct effect, but in general, they do. And in general, they have vertical against the state, also in this case, the state against me, and horizontal direct effect. So we can see this from like the GDPR, for example. I can use the GDPR against the member state administration, for example. I can use it against my employer. I could again use it against my neighbor if the neighbor falls under GDPR. So it has really a broad direct effect, vertical and horizontal, right? Decisions also have direct effect, but only vertically and only for the person they're addressed to. So that is not really that important. And now we get to our main issue, because we now discuss direct effect of primary law and of regulations. Regulations, there's no problem generally, but direct effect of directives is a huge legal issue in EU law. And we kind of understand why, right? Because we talked about the directive and the need for implementation. So in general, we said that because the regulation is not directly applicable in the member states, it can also not have direct effect. Like, there's no way to invoke it before a court or administration, be it against the state, be it against an individual, if it hasn't been implemented, because the state needs to implement it, because the treaty says it is only directed at the state, right? So in the ECJ has also confirmed this, like in general, there's no direct effect of directives, but there is one main exception, and we'll talk about this right now. So the ECJ has basically held that in order for directives to have direct effect, which means that I can directly invoke the directive in front of a national court or administration, the provision of the directive, and realize that we always talk on a provisional basis. So we never decide whether the whole directive or the whole regulation has direct effect. We always have to look at the individual provision, whether that gives direct effect. Now, it must be clear and precise and unconditional. So these are the normal criteria. And now, usually we would say there is further implementation required, which is why the directive has no direct effect. But the ECJ has said, well, if the state doesn't transpose the directive, so states usually have an implementation period and there's an implementation deadline, usually it's 2 years, and the ECJ says, well, if this implementation deadline passes and the directive has not been implemented into national legislation, or it hasn't been fully or correctly implemented into national legislation, then directives, and this is really important to realize, can have direct effect. So what would this mean? Well, I can actually invoke a provision of the directive, even though it isn't national law, technically, because, well, at least it hasn't been implemented into national law. It hasn't been transposed into national law. I can directly invoke the directive, for example, to get a claim, to get right to withdrawal, maybe, in a legal case before a national judge or an administration. Now, one important caveat is that the ECJ has said that directives may only have vertical direct effect. So, and not like the state against me, which would also technically be a vertical case, but only the individual against the state. Why? Now, basically because this is a sanction for the state. Like, the problem that the ECJ saw is that basically states can decide not to implement a directive. For example, this makes a lot of sense. Like, let's say that, for example, a directive says that the state has to pay me 1,000 euros a month to go to university. Like, every student needs to receive 1,000 euros a month. And states have 2 years to implement this directive. Well, now the state doesn't really want to implement because it will cost a lot of money. So they might not. So they might say, well, then the commission has to sue me. It all takes a lot of time. We will just not implement. So now the problem is that I can sue the state and say I want 1,000 euros based on a directive, because if it doesn't have direct effect, I can't do that. Now, there is still Frankovic, which you remember, I might be able to claim compensation, but it's tricky. There need to be additional criteria and stuff like that. So the ECJ has says, well, in these cases where the state just doesn't implement, we will sanction the state and we will allow direct effect of directives. So we will allow the individual to use the provision of the directive directly against the state. Right? Direct effect against the state. Vertical direct effect. Now, what is important is that the ECJ uses a very broad definition of state. So state is not only the government, it's not only national administration. It might also be like state-owned enterprises that I could invoke this against. It might be universities. This is the Foster decision. But only in these scenarios, not the state against the individual, because the state has to be sanctioned, right? We can't allow the state to use the directive against the individual. So you can really tell that this legislation is based on like common sense, like the idea of sanctioning the state. And the ECJ has also, in principle, held that there's no horizontal direct effect of directives, so no direct effect between private parties. So when we come back to, let's say, the right to withdrawal, right? Let's take a case. I order something online, and this is not the case anywhere, but let's say that the Consumer Rights Directive has not been implemented by Germany. So I want to withdraw from the contract of something I bought, like at Amazon. And Amazon says, well, the German civil law doesn't have right to withdrawal. So now I sue, and the court says there's no right to withdrawal. Now, if I want to invoke the directive, this would be a horizontal case, because the company I'm suing or the person I'm suing is a private party. And the ECJ says in these cases there can't be a direct effect, so I could not invoke the right to withdrawal from the directive. So we would apply national law. I would lose my case. And now, always keep this in mind. Now there is still Frankovic. So I could sue the state now for the damage I've received because I couldn't rely on the directive and because the state didn't implement. But remember this, vertical direct effect, yes. Me against the state, yes. Me against a company or an individual, no. No horizontal direct effect between parties. This is Marshall, ECJ Marshall decision, and it has been confirmed a lot of times, right? So if you remember something from this video regarding direct effect of directives, remember provision must be clear, precise, unconditional. Implementation deadline must have passed, and it has not been implemented by the state. Then the directive provision can produce direct effect, but only vertically, me against the state. Not the state against me, not horizontally against private parties, right? So now that we've accepted this rule, we have to talk about exceptions, which are not real exceptions, because I think the ECJ has never actually confirmed that it allows horizontal direct effect between private parties, but there are decisions where it does in fact allow horizontal direct effect between private parties. This is now getting really complicated, so just remember the general rule if you remember anything. But I'll talk about the exceptions. So, right, the argument is sanction for the state. We talked about that. So now
let's ask the question, is there really no horizontal effect of directives? Never. Well, in general, no, right? The ECJ says the directive can never be invoked to impose negative legal effects on a private person, right? Including disapplying national law. So there's no direct horizontal effect, and we have learned, like remember our requirements, if we don't have direct effect, we can't have primacy. So at the least, we can't disapply national law based on this provision. So we would still apply national law, even though the directive says something else and the implementation deadline has passed. I can't invoke the directive, so there's no primacy in the sense that I will disapply national law. But the first exception, which is not a real exception, we've already talked about, because we talked about that primacy also includes interpreting national law according to EU law. And the ECJ has held that only if the implementation deadline is passed, this is really important, only if the implementation deadline has passed, national law must also be interpreted in accordance with a directive that has not been implemented into national law. So if the implementation period has passed, then we must interpret our whole national law according to the directive as far as possible, right? So in my case, against another private party, I might not be able to rely on the directive, but my national law may be interpreted in such a way through the directive that I still win the case. Now, technically, this is not horizontal direct effect because I don't apply the directive. There's no primacy. I don't disapply national law, right? I only interpret the national law in accordance with the directive. But the result, if the interpretation is possible, is kind of the same, right? I win my case against another individual based on national law. That is important, but national law interpreted according to the directive. So this is Marleasing. So this is kind of through the back door, like a direct effect. It isn't technically a direct effect. This is really important, like that you remember that in this case, we don't actually apply the directive and we don't disapply national law because without direct effect, there is no disapplication of national law. But we will still interpret national law according to the directive. And this might still achieve the same result for me, which is that I win my case against the other private party or against the company, right? So for example, take right to withdrawal. My national law, I order something at a shop online. My national law doesn't have a right to withdrawal, but it has a provision that can be read as right to withdrawal until like day 14. So now I can't invoke the directive. I can't say I have a right to withdrawal from the directive. I can't disapply national law because there's no direct effect of the directive. But the court must interpret the national law insofar as in a way that it complies with the directive as far as the wording will allow it, right? No contra legem, like the court can't read something into the law that isn't there, but they have to interpret it as far as possible in accordance with the directive. So if there's like some provision in national law that will allow the court to give me a right to withdrawal, I will win the case against the private party based on national law, and not based on the directive, but I still will win the case. So you could kind of argue that this still defeats the purpose, right? Because the argument from the ECJ is that they don't allow horizontal direct effect because it would conflict with the rule of law, because the other person, the other private party in the case doesn't know that the regulation applies. Like it only knows like national law, and it maybe has looked at like regulations because it has to follow regulations. But it doesn't have to look at directives because directives have to be transposed. So now, technically, I don't surprise them with like the directive, and I say I win this case because of the directive. But I still say, well, there is this directive that the state hasn't implemented that you didn't know about. But now the court will use this to interpret national law in a way where I will win. So you could argue that this still is an issue for rule of law, right? But in general, because technically it's not direct effect, it is accepted that we will always interpret national law according to a directive after the implementation deadline has passed, right? The second case is, so to summarize, we have a negative effect, but only from national law interpreted according to directive. And this is why to the ECJ, this is not horizontal direct effect, because it doesn't give negative effects directly to the individual through EU law. Not directly, only indirectly, right? And the second one is actually a case where the ECJ has allowed horizontal direct effect with negative effects for a private party. And if you want to look more into that, you can. This is a CIA security. And the ECJ doesn't say that it does horizontal direct effect. But this was a case, I will really broadly paraphrase it, where a company, I think it was again like an Italian company, sued another company, like the CIA security, like a security company, and won by invoking a directive. So one directly, and the national court directly applied a directive provision which hadn't been implemented into national law. And the reason was that not only had the implementation deadline passed, but there was another breach of the directive, because the state, the directive said that basically the state has to notify certain provisions of national law that regulate security equipment. And the state had not only failed to implement a directive, but it had further failed to notify, the commission of these national rules. And in this case, the ECJ held that actually the national court can apply a provision of the directive because there was this additional failure of the state to not only not to implement, but also to breach the directive. So this, as I said, really an exception to the rule. So this is not, I would say, that important. Just know that there is these cases, right? The more important exception is obviously the interpretation. So in this case, the ECJ held that basically the negative consequence is only incidental. Well, that is really to be discussed, I would say. Okay, so this is all I wanted to basically talk about. Just to summarize, I made 2 decision trees, so we can have a look at that. And basically along these decision trees, you can kind of decide if in an individual case, we will apply national law, or if we will disapply national law and only apply EU law. So first is the decision tree for a regulation. This is quite easy. In order to apply a regulation, we only have to ask 2 questions. So first we would say we need scope of EU law, right? If we look at the requirements, but scope of EU law I kind of skip, because if there's a regulation applicable to the case then obviously there is scope of EU law. And then the second question we won't really ask with the regulation if it has direct effect, because in general the ECJ has had that regulations have direct effect, and if you have a problem with direct effect, for example in an exam, it will always be the directive, or primary law, but most of the directive. All right. So basically, if we have a regulation, like scope of EU law, we have a regulation. The only question we need to ask ourselves is, do we have a conflict with national law? Do we have a national law provision that is in conflict? Now, if we don't have any national law, we will just apply the regulation. That's not a problem. But if we have a conflict with national law, then basically the first rule of primacy applies, which is interpretation up to the wording limit in accordance with EU law. So we would say, can we interpret the national law according to the regulation to basically get rid of the conflict? Now, if we can, then we will just apply the national law, read in accordance with the regulation. But if we can't interpret the national law according to the regulation, because it would be against the wording of the provision, then we would apply the regulation. This is classic primacy in the sense that first we need to interpret, and if we can't interpret, then we need to disapply national law and only apply EU law to the individual case. Now again, as I said, the national law will remain valid. So in another case where there is no scope of EU law or there is no conflict with the regulation, we can still apply the national law, right? So this is the easy case. The more difficult case is the directive. So the directive is a lot more complicated. If we look at the directive, well, first of all, again, we need obviously scope of EU law. So this is not an issue if we have a directive. Then again, we need a conflict with national law. This is a step I skipped here because otherwise the slide is a bit like too much. But we need scope of EU law. We need a conflict with national law. And now we need to ask the following questions. Well, the first one is kind of about the conflict. So the first question with a directive we always have to ask is, has the directive been correctly implemented into national law? Well, if it has, then actually we don't have a conflict, right? Because if the directive has been implemented into national law correctly, then there's no conflict between EU law and national law because we just apply national law. So no primacy, no need to interpret, right? No need to disapply, we just apply national law, right? Okay, let's say the directive has not been implemented correctly into national law. Second question, now I'm doing them a bit in the wrong order, but you remember the slide. Second question, has the implementation deadline passed? Now, if the implementation deadline hasn't passed, there's no primacy at all, right? Remember. So we would only apply national law. We would not disapply national law, and we would not interpret in accordance with EU law, in accordance with the directive, because the ECJ has held that even the need to interpret according to the directive is only there if the implementation deadline has passed. So we would just apply national law. For those that want to go deeper, there is still some requirements for the state in this case. Like if the implementation deadline has not yet passed, the state is not allowed to actively legislate against the directive. I think it's Inter-Environmental Wallonie is the decision. You can look it up. It's like basically the state must not boycott the directive even before the implementation period. But for our case, this is not necessary, right, to know. So if the implementation deadline hasn't passed, again, we will just apply national law without interpreting, without anything, right? Okay. So let's say the directive has not been implemented correctly and the implementation deadline has passed. So we have two criteria for direct effect. And now the third criterion for direct effect is that the provision we want to now apply in our case has to be clear, precise, and unconditional, right? And basically this is something that maybe you have to interpret, or in the end the ECJ would interpret this and would say if this directive provision is clear, precise, and unconditional. If it isn't, right? If the directive is not clear enough, like it doesn't give us enough of a legal consequence in our case, then we would apply national law. Because, why? Because no direct effect. And without direct effect, there can't be disapplication of national law. We would not disapply national law, we would apply national law. But the ECJ has held, mar leasing, that after the implementation deadline has passed, even without direct effect, right, we still need to interpret according to the directive. So this is also one of the requirements of primacy technically, right? But we don't disapply national law if we don't have direct effect of the directive, but we still need to apply the national law according to the directive. So this could lead to the result, even in a horizontal case, that I win the case based on national law, but national law interpreted according to the directive, right? So now let's say the provision we want to invoke is actually clear, precise, and unconditional. it has not been implemented and the implementation deadline has passed. So what is this? Well, this is the classical case of direct effect of directives. So in this case, the directive provision can have direct effect. And if the provision can have direct effect, that would also mean we disapply national law, primacy, right? So the final question, according to the ECJ, we now need to ask is, do we have a vertical case? And vertical or a horizontal case? And vertical case only means reliance on the directive, invoking the directive provision against the state. Broad definition of the state, but against the state, right? So if we have a vertical case, so we have a case in which the directive is not invoked against a private person, so the negative consequence only hit the state, right? Then if we have direct effect, we will apply the directive, right? We will disapply national law. So this is the only case in which we have like full primacy in the sense that we test the directive for direct effect. Now we also have a vertical case. So now remember, obviously we would still try to first interpret, but if we can't interpret in accordance with the directive, then we would actually disapply national law in this case and apply the directive. But we would only do that because the directive has direct effect and it is a vertical case, right? Okay, so let's say the directive could have direct effect, clear and precise, implementation deadline has passed, not implemented, but we have a horizontal case. So it's me suing my neighbor, it's me suing a company. Now the ECJ says, no, we can't apply the directive in this case, so we can't disapply national law. We won't disapply national law and apply the directive in the individual case. But again, the ECJ has said, even without direct effect, because it is a horizontal case, we still have to interpret according to the directive. So still, in this case, we would try to interpret the national law as much as possible in accordance with the directive, which could lead to me winning the case. But if this is not possible, like we can't interpret the national law in a way that I win the case, like according to the directive, then we stop. We don't disapply national law in this case against another private individual. So I lose my case. Now I lost my case. What can I do? Well, you might remember Frankovic. I can sue the state and I might be able to claim compensation from the state for the damages I received because the state did not implement, and because of that I lost my horizontal case against another private party, right? So this is all basically I wanted to talk about today. Especially, of course, this issue of direct effect and the direct effect of directives, right? So just remember that not all EU provisions have direct effect. We talked about primary law. We talked about regulations, which do have direct effect generally. And we talked about directives, which usually don't have direct effect, which also means, because think of our requirements for primacy, for disapplication of national law, right? That if we don't have direct effect, we don't disapply national law, right? But remember that even if we don't disapply national law, we still have the obligation out of primacy to interpret the national law according to the EU law, right? So I will upload these slides. You can have a look. You can actually have a look at these decision trees. But I hope that this this video made it clear what the relationship is between the EU legal order and the national EU national legal order. Sorry, it's been a lot of talking, and how legal acts of the EU can actually go into the national legal order and can actually, in the end, not only forced to interpret national law, but also can disapply national law up to constitutional provisions if we follow the ECJ jurisprudence, unlike the conflict between primacy and the national constitutions, right? So I think most of the problems that you will face in EU law are better understood if you understand these basic principles of EU law and the relationship between EU law and national law, and why we can have conflicts between these two legal orders in the first place. All right, I'll upload those slides on YouTube. And if you have any questions, you can put them in the comments. If you have other, ideas for like videos like this that you would find helpful, then please write a comment, and I'll see you next time. Bye.